Now, the next part is conversion into LLP. Now, what is conversion into LLP? We have discussed in the beginning when we talk about first schedule, second, third, and fourth. Where second, third, and fourth talk about conversion of firm into LLP, talks about conversion of private company into LLP, and third, conversion of unlisted public company into LLP. Here they are telling that whenever these things are going to happen, they will happen as per the second, third, and fourth schedule respectively. And obviously, once it is going to happen, the formed LLP has to give all the information to the registrar. So understand, when it is a firm, partnership firm converting into LLP, then once it is registered as LLP, LLP has to inform even the register of the firms earlier about this kind of change. Similarly, in case of company being converted into LLP, information has to go to the registrar of the companies for them to make the changes. Because then in their books, you will be removed out. And here in the registrar, here it will be maintained that you are now a LLP. All the assets, all the liabilities of the firm, the companies, okay, depending upon what association it is, depending on that, all will get transferred to what? The LLP. In the partnership firm, the partners will now become the partners here. The shareholders of the company will become the partners here, depending upon the agreement to the contrary. Correct? So these things are very, very simple. These are very, conceptual. So one reading of it, I think you'll be able to understand very easily. Okay? Conversion into LLP. Conversion from LLP firm into LLP. A firm may convert into LLP in accordance with the provisions of this chapter and second schedule. We know this. Conversion from private company to LLP as per this act, as per which schedule? Third. Conversion unlisted public company into LLP, it is fourth schedule. Registration and effect of conversion. The registrar, on satisfying that a firm, private company, or unlisted public company, as the case may be, has complied with the respective schedules, provision of this act, and the rules made thereunder. That is what is given in the schedule, what is given in the act, and what is given in the rules with respect to conversion. If you have done everything, then the registrar will be satisfied. Register the documents submitted under such schedules and issue certificate of registration in such form as the registrar may determine, stating that LLP is on and from the date specified in the certificate registered under this act. That means that firm, that private company, and that unlisted public company have now become what? LLP under this act. So if they're satisfied with everything that you have done, the LLP shall, within 15 days of the date of registration, inform the concerned registrar of firms, original one, or registrar of companies, private, unlisted, public companies, as the case may be, with which it was registered under the provision of Indian Partnership Act 1932, or the Companies Act 1956, now the Companies Act 2013, as the case may be, about the conversion and of the particulars of LLP in such form and manner as may be prescribed. Logic is very simple. Why you have to inform? Because they have to remove you from their name, from their register. And that is the reason information to them becomes very important. Register of firm under Indian Partnership Act, registrar of companies under the Companies Act. Okay, then. Upon such conversion, the partners of the firm, the shareholders of the private company, or of the unlisted public company, as the case may be, the LLP to which such firm or such partners have been converted, and the partners of the LLP shall be bound by the respective schedules, as the case may be applicable to them. So whatever is each of them's responsibility, as per the schedule, they have to fulfill them. They're bound by them. Upon such conversion, on and from the date of certificate of registration, which is issued by the registrar of the companies to the firm, LLP, the effect of the conversion shall be such as specified in the respective schedule, as the case may be. That means they'll get converted into LLP. Effect of registration. Notwithstanding anything contained in any other law for time being in force, on or from the date of registration specified in the certificate of registration issued under the respective schedule, as the case may be, there shall be an LLP by the name specified in the certificate of registration. So now the registrar has given certificate of incorporation, certificate of registration. In that, whatever name is there will become the name of LLP. Whatever date has become, the date will become the date of registration. All tangible, movable or immovable, and intangible property vested in the firm or company, as the case may be, shall become the asset or the interest, right and privileges, liabilities, obligation relating to the firm or the company, as the case may be, and the whole of the undertaking of the firm or a company, as the case may be, shall be transferred to or shall vest in the limited liability partnership without any further assurance, act or deed. Meaning is you don't have to execute one more detailing, okay, we're transferring everything. No. This registration is a conclusive evidence. Now all the assets, all the liabilities, all the tangible, all the intangible assets, all the obligations, everything will now get transferred to what? The company or the, to LLP, as the case may be. The firm or the company, as the case may be, shall be deemed to be dissolved and removed from the record of the registrar of firms and the registrar of companies, as the case may be. So I told you this part is very logical. First, they're telling you do as per the respective schedules. Then you inform the registrar. If registrar is satisfied, they'll register you. Then you have to inform to the original people, that is registrar of companies and registrar of firms. Then in that case, upon conversion, you have to do everything what is required by the schedules. And all your rights and duties will be obliged under the schedules. If at a registration will be what? You'll be on the date of registration, you will get that name for the LLP and you'll then work as a LLP. All the assets, all the liabilities, whether tangible, intangible, movable, immovable, everything will get transferred to what? LLP. Obligations, rights, interest, everything will vest with whom? The LLP. And this original firm or unlisted public company or private company, as the case may be, they will stand dissolved as from the date of registration. Simple? Yes. For an LLP, the central government may make rules for the provision in relation to establishment of people, place of business for the foreign LLP within India, and carrying on their business therein by applying or incorporating, with such modification as appear appropriate to the provisions of Companies Act or other regulatory mechanism as such composition as may be prescribed. Meaning is if there is a foreign LLP, they should have a POB in India. So where they should have, how they should operate, what documents they have to file, all of that will be given by central government through its rules. Okay, that is what they're telling. Then comes to compromise, arrangement, or reconstruction of LLP. Now, what is this compromise arrangement? What happens is sometimes LLP will be under a problem where they'll not be able to repay back the debts to the creditors. So they must have taken loan from the creditors or they must have taken supplies from the creditors. And now they are facing some financial crisis where their business is going under loss and they're not able to repay them back. So what happens is obviously they'll not file a petition for insolvency and call them to be insolvent and run away and all those things will not happen. However, they will try to negotiate with that of creditors. They'll try to bring in a kind of arrangement among them where they'll try to compromise. So creditors will try to compromise, always understand something is better than nothing. So they'll be ready for some kind of compromises here, where sometimes they'll waive off the interest, or they'll waive off the part of the loan, or they'll give extension to the period of loan. Installments amounts will be changed. Something like that will be made. Okay. Or they'll ask for additional securities and all. Something will be made by them. So that's called compromise. Arrangement would be same thing, same manner only. Then why you call it compromise between the creditors or the partners? Sometimes partners also, they'll be having some kind of arrangements done between the change in the PSR. Or maybe sometimes situation is such that partners are not coming to a consensus regarding any matter. So what they'll decide, okay, let us have some other way around through which we can come to an understanding that we will follow this route. So this kind of compromise, this kind of arrangements are made by the partners where they're not able to settle with one of the decisions. So these are considered to be compromises and arrangements. So there they're telling when compromise arrangements happen, what should be the procedure and how do you follow it? Again, theoretical aspects, one reading, you'll be able to make sense out of it. Compromise or arrangement of LLP. Where a compromise or arrangement is proposed between LLP and the creditors. I told you when you're not able to pay the creditors, you have to conduct a meeting, negotiate with the creditors. That's called compromise and arrangement. Or between LLP and the partners. So when you're not able to come to a decision, when PSR you want to change, distribution share you want to change, some kind of internal changes you want to make, then there has to be compromise and arrangement. The tribunal may, on application of the LLP or any of the creditors or the partners of LLP, or in the case of LLP, which is being wound up by the liquidator. So see, who wants the compromise? Creditor. Who wants the compromise? Designated partner. Who wants the compromise? Partner. Who wants the compromise? LLP. Or sometime LLP is going under liquidation. So now the arrangement is required by whom? The liquidators. So any of them can make application to whom? Tribunal. Order a meeting of the creditors or of the partners, as the case may be, to be called, held and conducted in such manner as may be prescribed as the tribunal directs. So tribunal, whenever somebody is making an application for compromise and arrangement, tribunal will say, please conduct the meeting for the required people. If it is for the creditors, creditors meeting will be conducted. If it is partners, partners meeting will be conducted. And it will be held, conducted in the manner as tribunal is telling. Where, what, how, everything will tell, tribunal will tell. If majority representing 3/4 in value, majority in number, 3/4 in value, we do it as a part of notice and all that. Length of notice and all. Where you want to get a shorter notice. We talk about majority in number, 3/4 in value. Of the creditors or partners as the case may be, at the meeting, agree to any compromise or arrangement. The compromise or arrangement shall, if sanctioned by the tribunal, by order be binding on all the creditors and all the partners as the case may be, and also on the LLP, or in the case of LLP which being wound up to the liquidator or the contributors of the LLP. Meaning is what? They're telling meeting is conducted, for example, about the LLP and the creditors. Creditors are now negotiating for compromise. Agreed? How many of them will agree? Majority in number holding 3/4 in value. Okay, suppose there are 3 creditors only. Out of them, 2 are agreeing, and these 2 together are holding 80% of the credit, amount to be paid by the LLP. So if these 2 holding 80% are agreeing, then we have no problem. It is assumed that all 3 have agreed. but tribunal has to be satisfied. If tribunal is satisfied and majority and 3/4 value thing happens, then whatever decision is given by tribunal now, whatever arrangement is decided now, will be on all the creditors, on the LLP as well. And if it is liquidating, on the liquidators as well. That means we are not telling that those who have agreed, remaining will get exit opportunity and all that. No. If this much criteria is fulfilled and tribunal is agreeing to it, it is binding on everybody. Provided that no order sanctioning any compromise or arrangement shall be made by the tribunal, unless tribunal is satisfied that the LLP or any person to whom by whom the application has been made under subsection 1 has disclosed to the tribunal by affidavit or otherwise all material facts relating to the LLP, including the latest financial position of the LLP and the pendency of any investigation proceeding in relation to the LLP. Be creditor, be liquidator, be any partner. Whoever has made application to tribunal has given a clear-cut or detailed understanding about the LLP's financial position and all the matters, and including the current investigations going on. Then only LLP decisions will be binding. The tribunal decision will be binding. So whoever is making application to the tribunal has to give complete information to whom? The LLP, the tribunal. An order made by the tribunal under subsection 2 shall be filed by the limited liability partnership with whom? Registrar, within 30 days. Whatever happens, ultimately you have to inform whom? ROC. After making such order and shall have effect only after that has been so filed. If default is made in compliance with the provision of subsection 3, LLP and every designated partner shall be liable to so and so punishment, and for each day 100 rupees per day, and continues 1 lakh maximum for LLP, 50,000 for designated partner. The tribunal may at any time after an application has been made under this section stay the commencement or continuation of any suit or proceeding against the LLP. On such terms, the tribunal thinks fit unless application is finally disposed of. That means they can stop the proceeding, okay, delay the proceedings, anything they can do. Okay, till the time it is disposed of, tribunal has complete control over this kind of prosecutions or this kind of proceedings. So here what you have to remember is compromise arrangement between creditors or partners. People making application would be any of them, or it could be liquidated in case of winding up. 3/4 in value, majority in number, and tribunal has to sanction. Tribunal will sanction only if current information is given to him. Whatever is decided, ultimately binding on every person. They have to fulfill it. Okay, and they have to inform of ROC. And then the punishment given. Power of tribunal to enforce compromise or arrangement. Okay. Where tribunal makes an order under section 60, just now we discussed. Tribunal made an order now. Okay. 60, sanctioning a compromise or arrangement in respect of LLP. It shall have the power to supervise the carrying out of the compromise or arrangement. That means if they're telling, now they're going to, creditors are ready for waiving of certain amount. Then see whether really that thing has happened or not. And after that, at least the LLP is regularly paying the amount or not. Everything will be supervised by tribunal. And may at the time of making such order or any time thereafter, give such directions in regard to any matter or make such modification in the compromise or arrangement as it considers necessary for the proper working of compromise or arrangements. So any order which they believe is important for this compromise or arrangement to happen correctly, the order they can pass. That is the power given to tribunal. If the tribunal aforesaid is satisfied that the compromise or arrangement sanctioned under section 60 cannot be worked satisfactorily, that means they're believing either of the parties are not doing their work appropriately, with or without modification, if any, either on its own motion or on the application of any person interested in the affairs of the LLP, may make an order for winding up of the LLP, and such an order shall be deemed to be an order made under section 64 of the Act. 64 is what? Involuntary, made by the tribunal. Just an equitable ground for studied, that one. Okay? So if you don't follow the order of tribunal, will tribunal allow you to sustain? No. Then in that case, they'll be ordering you for what? Winding up of the LLP. Okay? Then. Provision for facilitating reconstruction or amalgamation of LLP. Reconstruction is what? Revival of the LLP if there is a loss or not. Amalgamation is two LLPs coming in together. Where an application is made to the tribunal under section 60 for sanctioning a compromise or arrangement proposed between LLP and any other person, as I mentioned in that section, like creditors, partners, etc., or liquidator. And it is shown to the tribunal that compromise or arrangement has been proposed for the purpose of or in connection with a scheme for reconstruction of the LLP or the amalgamation of any two or more LLPs. And under the scheme, the whole or any part of the undertaking, property or liability of any LLP concerned in the scheme is to be transferred to another LLP. The tribunal may, either by order sanctioning the compromise or arrangement or any subsequent order, make provisions for all or any of the following matters. Meaning is that telling, when you applied for compromise and arrangement to tribunal, that then tribunal understands all these things have been done because they have intended merger, intended, reconstruction plan. Then what tribunal will do? He will pass the order, but taking into account all this. Namely, the transfer of to the transferee LLP of the whole or any part of the undertaking, property or liabilities of the transferor limited liability partnership. The continuation by or against the transferee LLP of any legal proceedings pending by or against any transferor. The dissolution without winding up of any transferor LLP. The provision to be made for any person who, within such time or in such manner, the tribunal dissent from the compromise and arrangement, and such incidental, consequential, and supplementary matters as are necessary to secure that the reconstruction or amalgamation should be fully and effectively be carried out. That means tribunal is going to pass orders regarding all these matters also, along with this compromise and arrangement. Okay, so once again, understand. Under the scheme, the whole or any part of the undertaking, property or liability of any LLP concerned in the scheme is to be transferred to another LLP. The tribunal may, either by order sanctioning the compromise or arrangement or any subsequent order, made provision for any or all of the following matters. That means they'll make provision with regard to what all has to get transferred, whether proceedings continued now, which are pending now, should be continued by the transferee LLP also. Okay, then any other directions can be given by tribunal, and any other matters incidental to the main matter, those orders also can be passed by the tribunal. So remaining on all these matters also they can tell. Then, provided that no compromise or arrangement proposed for the purpose of or in connection with a scheme of amalgamation of LLP, which is being bound up with any other LLP or LLPs, shall be sanctioned by the tribunal unless tribunal has received a report from the registrar that the affair of LLP has not been conducted in the manner prejudicial to the interest of the partners or any of the public interest. Tell me, will tribunal ever pass any order which is against the public? So if it is an escape route for the LLP, then okay, I'll join hands with the another LLP. Then we'll be known by completely new name, and my creditors will not be able to catch me anymore because I was original LLP, I was owing them, but now it's a new LLP altogether, amalgamated one. I'll not be responsible. So don't you think before any order is passed, tribunal is going to first inquire the matters with registrar to understand the real picture? Yes. That they're telling no compromise arrangement agreements can be done without information getting from whom? Tribunal, from registrar. Provided further that no order for dissolution of any transfer of limited liability under clause 3 shall be made by the tribunal unless official liquidator has, on the scrutiny of the books and papers of the LLP, made a report to the tribunal that affairs of LLP have not been conducted in wrong manner. So if you look at the above italic 3, they are telling order can also be passed with regard to the dissolution without winding up of any transfer or LLP. Sometimes what happens is they tell we're not amalgamating. One LLP is liquidating and all the assets are getting transferred to another LLP. That means the next LLP is acquiring this LLP. So this LLP is getting wound up and this LLP will get all the assets. So when it is getting wound up, liquidator will be there. So liquidator also has to give an written consent or written understanding to the tribunal that this entire arrangement is happening because of what? Not because they're carrying it fraudulently. It is good. They have not done anything against the public interest. Got it? So liquidator in this case has to give an understanding to the tribunal that yes, this wounding up, that is takeover by the another LLP, is not because of any matter which has been prejudicial to the interest of the partners or the any public interest. Then, where an order under this section provides for the transfer of any property or liabilities, then by the virtue of the order, that property shall be transferred to and vest in, those liabilities shall be transferred to and become liabilities of transferee LLP. And in the case of any property, if the order so directs, freed from any charge which is by virtue of compromise arrangement to cease to have effect. That means if there is any charge created on the asset, that will be free when it's transferred to what? The transferee LLP. Within 30 days after making an order under this section, every LLP partnership in relation to which the order is made shall cause a certified copy thereof to be filed with registrar for registration. Then if default is made by the company in complying with any of these provisions, then there is a punishment. Okay. Just for clarification, I'll just tell you once again what we have discussed. We are telling that this kind of compromise arrangement is happening with an intention in the mind of the LLP that they're going for reconstruction or amalgamation. Reconstruction is revival of the figures, that is upward, downward revaluation of assets and all. And when you talk about amalgamation, it could be either two LLPs coming together or one LLP is getting liquidated and one is getting carried away, taking over. Here they're telling tribunal only has to pass the order. If it is amalgamating, then in that case, you have to get an understanding from the registrar. They have not done anything which has been prejudicial to the interest of the partners or the public. If it is one is winding up and the other is taking over, then this liquidator has to give an understanding. Nothing has been done which is prejudicial to the interest. And in the case of compromise and arrangement, which the tribunal is going to pass an order, apart from the passing of order for compromise and arrangement, along with that, for all these matters also they can pass an order. How much assets have to be transferred? Okay. Then what will be the responsibility regarding the pending litigations? Will they be carried away by the new LLP also or not? Carried on by the new LLP or not? Okay. Then about resolution, how much will be carried out? How much will be disposed of? Everything for that also audits can be given. And all this information you have to give whom? ROC. One good reading at your end, I think it will be sufficient. Then comes to miscellaneous part, which are very simple. A partner who lends money to LLP has the same right and obligation with respect to that of a loan and other transactions as per the person who is not a partner. Understand, when partner is giving loan, it is not going to be partner is given as a part of contribution. It's not a capital. It's a loan. So with respect to that loan, partner will become what? Creditor. So is LLP responsible to pay the interest, principal, everything? Yes. Cannot say partner only, no, so will not give, no. When it is acting in the capacity of a creditor, he'll be a creditor only. The central government may direct that any provisions of the Companies Act. The central government may direct that any of the provisions of Companies Act shall apply to LLP with or without exception, modification, adaptation, as the case may be. So till now, there are certain Companies Act provisions which are applicable to LLP. If central government is making a rule, then this will be as per the Companies Act. Same will be applicable here also. A copy of an extract from any document electronically filed with or submitted with the registrar, or any information which is supplied to or issued to the registrar and certified through affixing digital signature in any proceeding be admissible as evidence as equal validity with the original document. So anything electronically filed with the MCA portals and all that will consider to be as an evidence, as if it is an original document. Because e-filing is a feature of the LLPUC. So everything is done electronically, but digital signatures and all, they'll be considered as if they are original documents and accepted as an evidence. Any document or return required to be filed or registered under this section Act with the registrar is not filed or registered in any time. Okay, then and there has been a delay of 300 days on the payment of additional fees of 100 per every day on which such default is continued. That means they're telling if it is not filed or registered in the time, may be filed or registered after the time, up to how much time? 300 days on the payment of additional fee of 100 per day of such delay. Okay, so the extension is given for filing up to 300 days, and for every day of delay, you have to pay 100 rupees. Enhanced punishment in case of limited liability partnership or any partner, or in case of LLP or any partner or designated partner, or such LLP commits any offense, the limited liability partnership or the partner or designated partner shall, for second or subsequent offense, be punishable with imprisonment as provided. But in case of offenses of which fine has been prescribed, along with the exclusive of punishment, with fine which shall be twice the amount of fine of offense. This is quite understandable. If anything else you do, you'll definitely have punishments to be done. If you continuously do it, then the punishment, the way they'll be giving it is going to be what? Compounding will not be allowed. In fact, you'll be paying double the amount of the fine. This you've already discussed as the part of compounding. Okay, one reading you can do of this also. The miscellaneous part, I think you should not focus much on. One reading, I think it will be done at your end. Differences between LLP and partnership. 2008, 1932. One is body corporate, one is not a body corporate. One has a separate status, one does not have. One is created by a legal process, one is created only by agreement. LLP registration mandatory. Perpetual succession for LLP. LLP uses the word LLP as the last name. Partners liability is limited. Mutual agency is not there in LLP. Two designated partners, yeah, there's no concept of that. Common seal not required in case of partnership. For all the legal compliance, designated partners are responsible. Here, all partners will be responsible. LLP is required to file annual returns and statement of account of solvency. Partners do not require any of those. Foreign nationals can become a partner in LLP. In foreign nationals cannot be a partner in partnership firm. Minor cannot be admitted to the benefits of LLP. Minor can be admitted to the benefits of LLP. I think you don't require my explanation here. Absolutely. When it comes to company, 2013, 2008, persons who contribute to LLP are called as partners. Here they're called as members. Internal governance is done by articles here. Here it is going to be governed by LLP agreement. Name of LLP contains the word LLP as a suffix. Partner company will have public company or private company, sorry, limited or private limited. Here minimum 2, maximum no limit. Company minimum 2, maximum 200 in case of private, unlimited in case of public. Limited liability partnership are liable for agreed contribution. Here they are liable to the unpaid value of the shares. Business is carried on by the partners. This is carried on by the board of directors. Minimum 2 designated partners. Here directors will be responsible. Private company minimum 2. Public company minimum 3. Maximum both will be 15 on. Clear? So I think this particular chapter is not very heavy. Okay. And some parts have taken faster because those are found to be very simple. One reading also will help you. Throughout, if you have been with me properly, I think coverage of this chapter will be enough. Some questions have been given to you for your practice. You can pick up the questions and revise them quickly. If there is any doubt regarding this chapter, please get free to get in touch with me. Do not delay when you're doing this chapter itself. See that your doubts are questioned and they're clarified then and there. Do not keep them pending when you're studying this part. LLP, for exam, will hold importance. You'll have question coming from here. Best part is you'll not have a scope of losing marks here. So see that you studied properly, coverage very little, question is going to be compulsory. So see that the preparation is 100%. Thank you.